independent offices of state.
I get that. The question is whether or not you will provide all of your documents and correspondence. That's the question. I don't need a history lesson.
Well,
we do have a presidential administration that's working to put its opponent in jail. I mean, that's a fact.
Has there ever been another time in American history when a president was involved in an insurrection trying to overthrow the government of the United States of America other than January 6th?
that was one of a long list of reasons that Mr. Herr gave for his decision. That
Give me one more reason.
He found that, look, I don't want to get into a discussion about this, but I will say one of them was that the president was completely cooperative in this matter.
It seems like you've created an office that would require an act of Congress, yet there's not an act of Congress that authorizes that.
And it is despicable that my Republican colleagues want to go after him for his stuttering problem.
Were you aware that DA Willis hired her friend Nathan Wade to prosecute President Trump as he met, that Mr. Wade met with the Biden White House on 2 occasions for 8 hours?
I don't know anything about it.
You're in court because you're choosing to try to stop Texas from enforcing the laws that the federal government is refusing to enforce.
Lisa Page said this in a text message to Peter Strzok: Trump's not ever going to become president, right? With a question mark. Peter Strzok's response: no, he's not. We'll stop it.
The undercover video featured an IRS official privately admitting that the IRS had been using AI to spy on Americans' bank accounts en masse in real time.
You've told us that it's a dangerous conspiracy theory to allege that the Department of Justice is communicating with these state and local prosecutions against Trump. You can clear it all up for us right now. Will the Department of Justice provide to the committee all documents, all correspondence between the department and Alvin Bragg's office and Fonnie Willis's office and Letitia James's office?
The offices you're referring to are independent offices of state.
I get that. The question is whether or not you will provide all of your documents and correspondence. That's the question. I don't need a history lesson.
Well, I'm going to say again, we do not control those offices. They make their own decisions.
The question is whether you communicate with them, not whether you control them. Do you communicate with them, and will you provide those communications?
If you make a request, we'll refer it to our Office of Legislative Affairs.
But see, here's the thing. You come in here and you lodge this attack that it's a conspiracy theory, that there is coordinated lawfare against Trump. And then when we say, fine, just give us the documents, give us the correspondence, and then if it's a conspiracy theory, that will be evident. But when you say, well, we'll take your request, and then we'll sort of work it through the DOJ's accommodation process, then you're actually advancing the very dangerous conspiracy theory that you're concerned about. Now, you were a judge, once nominated the highest court in our country. When you were a judge, I'm just curious, did you ever make political donations to partisan candidates?
No.
No, and you didn't because that would create the potential appearance of impropriety.
I didn't because there's a federal rule barring federal judges from making contributions.
Right, but under that same theory of attacks on the judicial process, like, shouldn't someone be owed like a jury of their peers and a judge that's non-biased rather than getting a judge from your political opponent's donor file?
I'm well aware that you're not asking a hypothetical. You're asking me to comment on a jury verdict in another jurisdiction which has to be respected. I won't comment on it. That case is still ongoing. The defendant
Mr. Attorney General, I hadn't asked you about the verdict yet. We were getting there. I was talking about the judge. And so let me ask you this question about your time as a judge. Was there ever a time when you were a judge when you had a family member who was personally profiting off of the notoriety of a case that was before your court?
Look, I'm going to say again, it's very clear you're asking me to comment on a case in another jurisdiction.
No, wait, hold on, Mr. Attorney General. Did you ever have a family member profit off of the notoriety of any case that you sat over?
Say again, you're asking
yes or no?
You're asking me to comment on a case currently.
Well, it seems you're connecting the dots, Mr. Attorney General. I'm just asking you as to a general principle, but you are aware that Judge Merchan's daughter was profiting off of this prosecution. You are aware that that creates the appearance of impropriety. You know the very reason there's a federal rule against judges giving donations is because it is the very attack on the judicial process that we're concerned about.
I'm sorry, I don't agree with anything you just said, but I'm not going to comment on it.
Okay, so you won't comment on it, Mr. Attorney General, but you had no problem dispatching Matthew Colangelo. Who's Matthew Colangelo?
That is false. I did not dispatch Matthew Colangelo.
Matthew
That's
Colangelo,
false.
Matthew
False.
Colangelo became the Assistant Attorney General at the very beginning of the Biden administration. Without having been Senate confirmed, goes and gets this senior role at the DOJ, and then after, I believe it's Gupta replaces Colangelo, Colangelo makes this remarkable downstream career journey from the U.S. Department of Justice in Washington, D.C., and then pops up in Alvin Bragg's office to go get Trump. And you're saying that's just a career choice that was made that has nothing to do with the lawfare coordinated by the DOJ.
I'm saying it's false. I did not dispatch Mr. Colangelo anywhere.
Well, do you know how he ended up there?
I assume he applied for a job there and got the job.
But see, you know what?
I can tell you I had nothing to do with it.
Well, you might not have had anything to do with it, but we've got this contemporaneous evidence in Mr. Pomerantz's book. So Pomerantz writes this book, which I'm sure you're aware of, where he says, we put together the legal eagles to get Trump. We got all these folks together and we assembled them for that purpose. And so when we on the Judiciary Committee think about attacks on the judicial process, our concern is that the facts and the law aren't being followed. A target is acquired, here, Trump, and then you assemble the legal talent from DOJ, Mr. Pomerantz, and you bring everybody in to get him. And meanwhile, the judge is making money on it. The judge is making money on it, or the judge's family's making money on it for stuff that you yourself wouldn't do. You know, no one's going to buy this. No one's going to believe it. It's going to create great disruption. And I am saddened by it because, like you, I have given my life to the law. I care deeply about the law, and I think that the lawfare we've seen against President Trump will do great damage well beyond our time in public service.
Our Republican colleagues seem to believe that the Department of Justice is secretly coordinating the now successful prosecution of former President Trump in New York. Is there any truth to this allegation? And what is your response to this allegation?
The case in New York is brought by the Manhattan District Attorney independently on his own volition and on his own determination of what he believed was a violation of state law.
There's no blinking at the fact that for the first time in American history, we do have a presidential administration that's working to put its opponent in jail. I mean, that's a fact. And that, an opponent who's a former president of the United States. Now, as I understand the facts, Jack Smith was the principal player in the IRS targeting of the Tea Party. He was a well-established record of prosecutorial abuse, and yet you appointed him to prosecute the former president of the United States, who happens to be running against your boss. Now, this is entirely your work, including approving an unprecedented search of a former president's home. And though you've just maintained that the local prosecutors are independent, it's a fact that in the Manhattan case, the third-ranking official in your department left it to join the local prosecutor's office to spearhead the New York prosecution. The Atlanta prosecutor strategized for hours with the White House counsel in advance of filing that case. And you've just refused Mr. Gates' request to reveal what communications your department and its employees have had with those local offices. So what are we to make of all of this?
Well, I have to disagree with the characterizations that you've made. We're happy to take into account the requests if you make them to us. That's the normal process, and we will respond to all.
Which characterization do you question?
Well, I disagree with your characterization that this person was sent by my office.
I didn't say he was sent, but it is rather odd that the third-ranking official in your office leaves it to go to a local prosecutor's office to prosecute this case.
Justice Department had nothing to do with that person going. He was the principal deputy to the third-ranking person in the
Caesar's
department.
wife, it's important that your department be above reproach, and clearly it's not.
They've raised the fact that this is the first time that there's been a prosecution of a president's allegedly gone after his opponent. Has there ever been another time in American history when a president was involved in an insurrection trying to overthrow the government of the United States of America other than January 6th?
The answer is no, but I do not intend to comment on the charges in the prosecution of the former president any more than I would comment on Mr. Herr's report. I just am not going to comment on matters that are before courts.
On May 15, 2024, you sent a letter to President Biden recommending he invoke executive privilege on audio recordings of his interview with Special Counsel Robert Hur. In this letter, you claim the precise concern is that executive privilege protects materials related to a closed criminal investigation where disclosure might hamper prosecutorial efforts in future cases. Is that correct? I think you stated that earlier.
Yes.
In this letter, you also wrote that you are concerned about the prospect of committees of Congress obtaining confidential records from Justice Department of criminal investigative files for the purpose of addressing highly politicized issues in public committee hearings. Is that correct as well?
Are you citing my letter?
Yeah, in the letter that,
That's correct, yeah.
Right. So let me go back. In the United States versus Mitchell, during the Watergate District Court case, Judge Sirica held that by releasing portions of a subpoenaed recording in transcript form for publication, the president's claim of confidentiality and that privilege associated with it was no longer valid since the conversations were no longer confidential. You produced the transcripts to this committee, correct?
Yes.
And prior to producing the transcripts to the committee, they were leaked to the press. So based on Mitchell, which is still good law, the recordings are, in fact, no longer confidential, aren't they?
Can I respond? I'm sorry, that's not what Mitchell was about at all. Mitchell was, first of all, about transcripts created by President Nixon, for which there was plenty of reason to believe that they were not accurate. And secondly, it had to do with the confidentiality of communications between Nixon and his staff. And once he provided the transcripts, the court said those communications were no longer confidential. That is not the allegation. That is not what we're asserting here. Here we're asserting confidentiality over the audio, not confidentiality, but protection of the audio in a criminal investigation, an interview, not a staff meeting.
Did the fact that he was interested in going after the very people who were targeted by the IRS about a decade ago, did that have any influence on your selection? Okay, let's put up this slide here. This is from Jack Smith to some other folks in the Justice Department, and it says, could we ever charge a conspiracy to violate laws of the U.S. for misuse of such nonprofits to get around existing campaign finance laws? Jack Smith was looking to prosecute the very people who were targeted by the Obama IRS.
I don't know. You have excerpts from an email I've never seen. You should know that
IRS Commissioner Sarah, I'm just asking, did this weigh into your decision? Did you know about this?
No,
What Jack Smith was trying to do?
I also don't know if it's true now.
Special Counsel Hur found that then former Vice President, President Biden, had retained and disclosed classified information. Isn't that true?
Mr. Hur has presented a long report.
Isn't that true? I mean, come on. I'm practically quoting right from it. You wouldn't disagree with that
I won't disagree
assessment.
I'm not going to comment on his report. He sets forth, I appointed him to investigate the allegations about classified documents.
So the reason that we end up talking over you is because a simple question like that goes unanswered. You're non-responsive. You're non-responsive to the question. Because that is what Mr. Hur found. And then he also found, and you're not going to like this because I'm going to quote from it. From this, he basically says here that he found Mr. Biden to be sympathetic and here he is, a well-meaning elderly man with a poor memory. And so he made a prosecutorial decision that he wasn't going to prosecute. Are you going to dispute that? You're not disputing that, are you?
Mr. Hur's report.
Okay, you're going to say it stands on its own. Okay, so it stands on its own. No, because you're not intent on answering. You want to be non-responsive. You want to filibuster.
I'd like to answer your question.
Do you dispute that? So let's just face it. Mr. Biden has not been prosecuted, correct?
That's correct.
And the rationale given by Mr. Hur is because he was a sympathetic, well-meaning elderly man with a poor memory, and he thought the jury would have sympathy towards Mr. Biden.
That was one of a long list of reasons that Mr. Hur gave for his decision.
Give me one more reason.
He found that, look, I don't want to get into a discussion about this, but I will say one of them was that the president was completely cooperative in this matter.
That's the reason, huh? Okay, all right.
You asked me one of the reasons, that was one of the reasons.
The issue that we have here, you don't want to give us the audio tape. You don't want us to have the recording. But ultimately, the issue is whether the transcript actually supports the special counsel's determination. Now, your office has basically pled two things in court, claiming, number one, executive privilege, and number two, this kind of interesting novel approach saying deep fakes, AI. Right, did they consult, did your staffer who filed that, did they consult with you about the deep fake AI rationale for not providing the audio to us?
You're mischaracterizing the filing. That was one of, again, a substantial number of arguments made in a Freedom of Information
Did they consult with you specifically about that idea, that notion where they were going to say something like, quote, this is from the pleading, the passage of time and advancements in audio, artificial intelligence, and deepfake technologies only amplify concerns about malicious manipulation of audio files, close quote. Did they consult with you about that provision?
I'm not going to talk about internal department deliberations. That was one of a large number of explanations in the document you're talking about.
And I'm talking specifically about that particularized rationale, and you don't want to discuss it, which is why you're non-responsive, and that's why we need the audio. And let me explain why. Because your attorney also said that you did alter the transcript, and they said it was filler words, repeat words, and, I. But you know what? We don't know whether they're the blank, he said there were blank times where there was silence. We don't know whether those were 1 minute long, 2 minutes long. We don't know if he sputtered for and, because those were edited out.
Attorney General, can you just briefly, without going into the facts of that case, address why that is the DOJ policy as it relates to the current president and any other requests about closed investigations?
Yeah, without referencing any case, we try to protect the law enforcement files of the Justice Department so that in future investigations, people are willing to cooperate with us.
I want to start by reading you the appointment clause of the Constitution. Article 2, Section 2, Clause 6 states, the president shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. Are U.S. attorneys nominated by the president and confirmed by the Senate according to this appointments clause?
They are appointed by the president and confirmed by the Senate.
Wouldn't you agree that U.S. attorneys are held to the appointments clause because they are delegated some part of the sovereign power of the United States, such as the ability to make indictments and charge individuals with crimes?
I would say that those are not the reasons why, and a court has already ruled on the question of whether special counsels are subject to the appointments clause in the Mueller case and ruled that they were not.
Was Jack Smith nominated by President Biden or confirmed by the U.S. Senate?
Look, you're asking me about a case, again, motions filed as just
This
cited
is a simple
another.
question.
No, I'm not
Was Jack Smith nominated by President Biden?
No, he was not.
Was he confirmed by the Senate?
No, he was not.
When was the special counsel statute passed?
There is no special counsel statute. There was an independent counsel statute that was expired.
So it expired. So what gives you the authority to appoint a special counsel? You've created an office in the U.S. government that does not exist without authorization from Congress.
There are regulations under which the Attorney General appoints special counsel. They've been in effect for 30 years, maybe longer, under both parties. The matter that you're talking about whether somebody can have an employee of the Justice Department serve as special counsel has been adjudicated.
You appealed, let me interrupt for a second, because you appealed to a regulation, a rule, whereas the Constitution says shall be established by law.
Yeah, the statutes.
Right, the statute, but you referred to a regulation, not to U.S. code.
May I answer? The regulation cites the two U.S. Code provisions that permit the Attorney General's appointment. Attorney General Barr cited to the same ones.
Are you familiar?
Even Attorney General Meese did that.
All right. Are you familiar with former Attorney General Meese's amicus brief?
No.
You're not.
I know that he's filed one because I read it in the newspapers, but otherwise I'm not familiar with it. But
Well, he raises some good questions that I agree with in there. It seems like you've created an office that would require an act of Congress, yet there's not an act of Congress that authorizes that. And even if it didn't require an act of Congress, and you've already admitted it, there was no act of Congress that established this office, it would still require, according to the Constitution, a nomination by the president and confirmation by the Senate. I want to move on to January 6th. Is it accurate to say that the DOJ is on pace to arrest roughly one protester a day in 2024, nearly 3 years after the incident?
I don't know what the pace is. The job is to arrest and bring to justice people who are criminally responsible, and as they are found, they will be arrested.
Is your office preparing to drop charges against more than 340 January 6ers charged with 1512C2 and release dozens from prison on that count if the Supreme Court this month reverses how your department has used that statute against them?
We respect the Supreme Court. Whatever the court rules, we will act appropriately.
So you'll have to drop the charges if the Supreme Court says that you did that
I'm not
wrongfully.
going to answer hypotheticals. We'll wait and see what the Supreme Court says.
What do you say in response to D.C. Appellate Court overturning 2 excessive sentencing requests sought by your office?
I say that is the United States system of justice working. If people think that they have inappropriate sentences, they can appeal their sentences. That's the way our system works, and we respect the results.
So you've refused to answer questions before us, including my questions about January 6th on multiple occasions here in this committee, but the Inspector General is preparing a report. Are you in receipt of that report yet? He's promised to examine the role and activity of DOJ and its components in preparing for and responding to the events at the U.S. Capitol. Are you in receipt of that?
I'm not in receipt of any report. You'll have to ask the Inspector General.
So I just want to ask you this question. Special Counsel Robert Hur said that this transcript was accurate. The written transcript was an accurate rendition of the audio transcript, correct? Except for some stutters.
Yes.
Okay. So what the gentleman from Arizona wants is that transcript audio with the and. Because Joe Biden stutters. He's had a stuttering problem his entire life. He overcame stuttering. He was made fun of in school, and he overcame this disability to become president of the United States, a leader of the free world. And it is despicable that my Republican colleagues want to go after him for his stuttering problem. They should apologize, and I yield back.
You said, but we have made clear that we will not provide audio recordings from which the transcripts that you already have were created. You went on to say that certain members of this committee and the Oversight Committee are seeking contempt. You're aware that a majority of this committee has marked up a contempt resolution, aren't you, sir?
Certain members includes the majority, yes.
It's a big difference, isn't it, sir? Isn't that significant? The fact that a majority of the committee charged by the Congress to inquire into the grounds for impeaching the President of the United States has marked up a contempt resolution. That's more important than certain members, isn't it, sir?
Majority.
Institutionally, more important.
A majority has sought contempt, yes.
You said that you will not be intimidated. Are you the arbiter?
I'm sorry?
Are you the arbiter, the decider of whether or not those tapes will be provided to this Congress at the subpoena of its committee to investigate the president?
Constitution requires me to protect the separation of powers and our ability to do investigations in the future. It requires me, and the court proceedings make that clear, to weigh whatever interests you have against the interests of law enforcement. The president has asserted executive privilege, and I have not heard a legitimate legislative reason why the audio is insufficient for any purpose, the legitimate purpose.
You know what demeanor evidence is, don't you, sir?
I'm sorry.
Demeanor evidence. You know what that is. You sat on the bench for decades. You know
I know what demeanor evidence is.
Okay.
I know what demeanor evidence is, and I've not been shown any reason why audio evidence of demeanor would make a difference in any legislative purpose.
Well, that's exactly what demeanor evidence is, sir. Witnessing and observing a witness as they testify. And what can be done by this committee is to observe the audio recording of the president testifying to see whether it comports with the transcript or whether it reveals things about his capacity or his veracity or anything else.
The first one has to do with your remarks earlier in the hearing where you were drawing the distinction between state court and federal court, and you were saying that state court is, quote, another jurisdiction. State, quote, prosecutors are independent. Third remark, prosecutors are completely independent. Fourth remark, action decisions of the state prosecutors are independent and they are taken of their own volition. What disturbs me about those assertions is what actually happened. I'll go with the Fani Willis case first, and it just mentioned that her friend spent some 8 hours in the White House discussing the case. Her friend, Fani Willis's friend. And my question to you is, if they're so independent, why were people who were involved in this state action up talking to the federal folks? How do you explain that?
Well, I don't know if it's true. I don't know anything about that. I don't know if she was there, what she was talking about. I don't know anything to support this allegation at all.
I think what I have here on my notes are, were you aware that the Fulton County DA, Fani Willis's office, coordinated with Special Counsel Smith, the Biden White House, and the Democrat-run January 6th committee during her investigation of President Trump? You're saying you don't know anything about that?
Yes, I don't know anything about that, no.
Would it disturb you if that actually happened?
Well, I imagine that if this committee asks a prosecutor for information, or if a prosecutor asks this committee for information, there may be conversations about that information. I think that is relatively routine. I don't have any idea whether there were any conversations with the special counsel, but it would not be anything wrong with people in different jurisdictions who have evidence obtaining the evidence.
Were you aware that DA Willis hired her friend Nathan Wade to prosecute President Trump as Mr. Wade met with the Biden White House on 2 occasions for 8 hours?
I don't know anything about it.
My question for you with respect to the department is, do you believe that Texas has a right to defend itself and to ensure that people who are in this country are not here illegally, and that we can protect the citizens of Texas from people unlawfully here who are committing crimes, to Elizabeth Medina, who's no longer with us because the federal government refused to do its job? Yet the Department of Justice is suing the state of Texas to stop implementation of SB 4. So do you say, as the Attorney General of the United States, Texas does not have a right to defend itself and to protect our citizens from murder by people who have come here illegally into the United States?
I say, as the Attorney General and as a human being, that my heart goes out to the families, that these are terrible, terrible events. And I say, secondly, as the Attorney General, the way to stop people like this from coming into the United States is to give more resources to the Border Patrol so that they can prevent that.
Mr. Attorney General, no.
You don't want to
We the people of Texas, money's not going to solve the problem when the Department of Homeland Security and the President of the United States refuse to enforce the law, ignore the policies, and Elizabeth Medina would be here alive today if we were following the law. Laken Riley would be here today if we had not released a killer onto the streets of the United States of America through parole policies that this administration is advancing. And the Department of Justice is suing the state of Texas in court, taking valuable resources to go against the people of Texas, when Texas simply wants to say that we should have a say in stopping people who are illegally, arrest them, and be able to deal with that on our own terms when the federal government refuses to do its job.
As reflected in our filings in that case, we are in court because the United States Supreme Court in Arizona versus the United States held that states cannot adopt their own immigration.
You're in court because you're choosing to try to stop Texas from enforcing the laws that the federal government is refusing to enforce. And by the way, that's not the same thing as Arizona. But a final question in my last minute. The Department of Justice did not assert privilege with regard to the transcript, correct?
That's right.
And you articulated a minute ago to my colleague that the best evidence rule says that the transcribed copy is admissible, right? But how can you claim privilege in the face of not just a legislative inquiry, but a constitutional impeachment inquiry? How can you claim privilege for something that you just testified was effectively the same thing? How can you claim privilege for the audio of the transcript you just testified was the same?
I just testified the words are the same. Sensing an audio is different. You have not given any explanation, and there's nothing in the impeachment resolution that would make a difference with respect to
Well, I respectfully
audio.
disagree. I would ask you one last question. Is the decision not to prosecute President Biden for effectively the same crime for which DOJ is prosecuting President Trump, is it because DOJ has determined the president is not mentally fit to defend himself and stand trial for his crime, but former President Trump is?
I say again, that's an inaccurate description of Mr. Herr's report, and I would rest on Mr. Herr's report.
It's the only assertion he made.
Investigators gave Hunter's counsel a heads up regarding their future investigative actions, specifically a pending search warrant. Does the Department of Justice usually tip off the defense counsel ahead of time to warn them that they'll be executing a search warrant?
You're asking me about a case that's in trial as we speak, and I'm just not going to comment on it. I think that's highly inappropriate for me to do.
Oh, this would not be inappropriate at all. Do you warn defense counsel ahead of time? Is this a standard operating procedure for the Department of Justice to notify that you're going to execute a search warrant?
I think I've answered this question before. It depends on the situation. In some circumstances, yes. In some circumstances, no.
On May 23rd of this year, were you in attendance at a state dinner for the President of Kenya?
Yes, I was.
Did Hunter Biden also attend the dinner?
From newspaper reports, yes.
Did you and Hunter interact in any way?
I have never spoken to Hunter Biden in my life, as far as I know.
Is the Department of Justice retaliating against whistleblowers?
No, that would be a violation of statute and a violation of
The
our...
Inspector General seems to think you are. I got this management advisory memorandum dated May 2024, notification of concerns regarding the Department of Justice compliance with whistleblower protections for employees with a security clearance.
I've read the management memo. I think it's a good memo. It doesn't say we've been retaliated against anybody. It says that there have to be additional protections with respect...
Is it just pure coincidence that Marcus Allen's security clearance got reinstated today? Whistleblower came in front of this committee. Democrats disparaged this guy, called him a conspiracy theorist. 27 months without his security clearance, and we find out today it's been reinstated?
Yeah, I'm sorry, I don't know about the facts, anything about the facts of that case. Retaliation against whistleblowers is against the law, and it will be punished.
3 people who've come and talked to this committee as whistleblowers have had their security clearance taken. Marcus Allen gets his security clearance put back in place today. And the Inspector General says he's got concerns, doing an investigation as we speak about what's going on.
I'm sorry, the management memo that you're talking about does not conclude there was any retaliation against
No,
anybody.
he's putting you on notice that he's investigating.
Doesn't say that.
Mr. Chairman, regular order.
So I want to ask you, can you talk a little bit about it, your actions, the efforts of the Justice Department to reduce violent crime in the United States, and more specifically, how you work with our local sheriffs, our local police department to reduce violent crime in our streets?
Yes, that is an important part of our obligation to protect the American people and America's communities. In 2021, soon after I became an Attorney General, I saw the statistics regarding the spike of violent crime that happened during the pandemic, and I knew that it was important that we do everything we can to drive that number down, both for the protection of the individuals who are hurt, but also for the people's sense of security in their communities and belief that the system will work on their behalf. So we issued a memorandum directing the strategy that we know worked and that worked in the last time I was in the Justice Department when I was a drugs and guns prosecutor, and then again when I was a prosecutor in Maine Justice. We cooperate with, we create task forces with our state and local law enforcement partners, sheriff's offices and police departments, so that the federal government can bring the benefits and advantages it has, sometimes money, sometimes technology, sometimes better statutes. And the sheriff's deputies and the officers on the ground can bring their knowledge of the community and their knowledge of the bad actors. So we can take the most dangerous criminals off the streets, the repeat shooters, those who are responsible for violence, the people running in gangs that cause violence, that we can bring cases both against individuals and against criminal organizations. That strategy.
If I can interrupt, you only have a minute and a half
left. The strategy's been successful. The homicide rate last year went down higher decline than in 50 years, and it is again going down this quarter by somewhere between 18 and 20%.
Do you believe that it's appropriate for somebody to run for prosecutor? And by that, also in Fulton County, Georgia, the same thing happened there with the prosecutor. Do you think it's appropriate? Do you think someone who's being interviewed for a position when they're going to be appointed, or somebody who is running for office and is going to be elected at this level of government in the judiciary should say what they want to do as far as putting somebody in jail before they've even seen the case? Is that appropriate, yes or no?
Your description of the Herr and Smith cases is inaccurate. I don't know whether your description of what the two district attorneys said.
Well, then you don't look at the news. Excuse me, Attorney General, because I only have a limited amount of time. Everywhere it was reported. It was, if you knew anything, you knew that Alvin Bragg and also, again, the prosecutor in Fulton County, Georgia, they ran on that. And that's wrong. That isn't equal justice for all. It's wrong. And this wasn't equal justice for all.
I wonder if you might just opine a bit or expound a bit on your work as it relates to gun violence.
Well, the Bipartisan Safer Communities Act has been extraordinarily helpful in our effort to combat gun violence. It's led to substantial numbers of prohibited sales of guns to minors who the statutes prohibit possessing because of conduct that they have engaged in. It's given us the authority to bring cases for straw purchasing that's led to crime guns and to gun trafficking to criminals, and in those ways has helped drive down the numbers with respect to gun violence. We have set up crime gun intelligence centers so that our state and local counterparts can trace guns that are found at crime scenes to determine whether they were used by serial killers, by serial shooters, to help us find out, to run the DNA off of the casings so that we can find hits on those people and arrest them and prevent them from committing further crimes. There's a host of things that the department has done, but the principal kind of violence we're worried about in the country is gun violence. That's what causes the enormous number of deaths we face every year.
What was your understanding of Jack Smith's reputation in the legal community?
Reputation was he had the highest reputation for both ethics and skill at being a career prosecutor.
Were you aware that individuals who had worked with him noted that, and I quote this, overzealous prosecutor who relies on ethically dubious tactics while investigating or prosecuting criminal cases? Were you aware of that?
I don't know what anonymous source you're citing there, but I certainly wasn't aware of it, no.
Well, let me cite another source to you. Are you aware that Mr. Smith's conviction against former Republican Virginia Governor Robert F. McDonnell and his wife, whom he accused of accepting payments and gifts in violation of federal corruption laws, was unanimously overturned by the Supreme Court? Are you aware of that?
Yeah, my understanding is from that is Supreme Court actually changed its view of that particular law. We respect the Supreme Court's ultimate determination. That has nothing to do with Mr. Smith.
Let me read you a quote from Chief Justice Roberts. He rebuked Mr. Smith's theory of case writing. Our concern is with the broader legal implications of the government's boundless interpretation of the federal bribery statute, which did not comport with the text of the statute or the precedent in the court. Does Mr. Smith's prior boundless interpretation of federal laws concern you?
Mr. Smith's case was supported by the Justice Department on appeal and by the Solicitor General's office. We respect the decision of the Supreme Court in their interpretation and narrowing of our anti-corruption statute.
Tell us, what work would you actually be doing instead of being here in front of us again today and having to be put through the ringer one more time?
Well, it's going to take a long explanation, but today, and I know you don't have time for it, the day begins with a threats briefing from the FBI and intelligence community about the threats this country is facing, both outside the United States and inside the United States. Threats from foreign terrorist organizations, from domestic violent extremists, from people intending to commit hate crimes. And we spend that time trying to allocate our resources and orienting our people so that they can deter and disrupt and prevent those attacks. That's what my morning would be, but it looks like we're out of time, so I'm happy to tell you what my afternoon would be if there's more time later.
It really flips the burden of proof and presumes that Americans engaged in conduct disfavored by the ATF are breaking the law unless they can prove their innocence, and that's simply turning, I think, it upside down. To what extent was your office involved in crafting or approving these policies?
Well, I approved all of those rules, and if you give me a minute, I'll go through each one so that you can explain to your constituents. So with respect to the brace, it does not apply to an arm brace applied by a disabled person or anyone else. The statute says if you have a rifle 16 inches or smaller, intended to be fired from the shoulder, that it has to be registered. The shoulder braces, which are only used to fire from the shoulder, turn it into a short-barreled rifle. They turn a pistol, a short-barreled pistol, into a short-barreled rifle. And
well, we know that there's a short period of time, and I think your department has even admitted a short period of time within which folks had to register, and we had millions of people across America that were supposed to register, a lot of whom were serving overseas at the time and couldn't do it within the specified period. And in fact, we sent a letter that asked your department to extend the period of time, at least extend the period of time within which they could register, and you guys rejected that. But since you reviewed and approved all these, and I know that you're crafting these at the behest of the president, which is certainly your right to do, one of the things I can't wrap my head around is the fact that on one hand, the administration is saying it's cracking down on guns. That was a quote. But here in D.C., the U.S. attorney, also under your ultimate authority, actively chooses to let hardened criminals who commit crimes with illegal firearms walk away scot-free from their criminal actions. Under U.S. Attorney Matthew Graves, here's what has happened in D.C. His office has declined to prosecute 32% of the carrying a pistol without a license cases in 2023, up from 15% in 2018. 60% of those convictions in 2023 were misdemeanors, which is up from 25% between 2018 and 2021. This rose to 48% misdemeanor rate in U.S. Attorney Graves' first full year, and then 60%, a record high last year. Were you aware of these statistics?
Mr. Graves is an experienced former career prosecutor. It's impossible to make these judgments based on numbers. It depends on what the evidence is in the cases. My understanding is that those percentages have increased now, and my information is that the crime rate in the District of Columbia in the first quarter of this year is now going down.
So in 2021, Derek Chauvin was convicted in a Minnesota state court by a jury of several felonies. Did you issue a statement after that verdict?
Yes, we always issue a statement after the verdict describing what the verdict was.
No, this was a state case. Did you issue a statement following the state court conviction?
I'm sorry, who is the person again?
Derek Chauvin.
Well, this was also a federal case.
Right, but this was before the federal case, and we got a verdict from the jury, and you issued a statement. Did you issue a statement, yes or no?
I don't know the answer to that. But
I have your statement right here.
We always describe the verdict.
This is a state court decision from a jury, and you said, well, the state's prosecution was successful. I know that nothing can fill the void that the loved ones of George Floyd have felt. So you agreed with the decision?
It's not a question of agreeing. It's a question of a verdict was occurred. And
okay, but you said the prosecution was successful.
It was successful because it led to a successful verdict.
So would you say that the prosecution in People v. Trump last week was successful?
Look, I guess by the definition of when somebody brings a case, if they get the verdict they ask for, it's successful without commenting on any particular case. And
you just said
certainly not
successful here.
commenting on yours.
You said that in this case, the prosecution was successful. So in a similar vein, would you say the prosecution in People v. Trump was successful?
I'm going to say again, you're asking me a tautology. When a prosecutor brings a case and the prosecutor wins the case, it is by definition successful.
What if the case is later overturned on appeal? Is the prosecution
And
successful?
we, of course, accept the decision on appeal, and then it's no longer successful.
So a successful prosecution is one where you get a jury verdict and then it's upheld on appeal.
Yes.
You were very quick the day of the jury verdict to say that the prosecution was successful in the Chauvin case. Would you say that by that definition, in the same way, the prosecution was successful in People v. Trump?
I'm not going to comment on that case. You can ask me 10 different ways.
Even though you're commenting on other state cases.
How does interference by politicians in criminal trials harm our democracy and the separation of powers?
Our criminal justice system proceeds on the understanding that the decisions will be made in the courtroom. without political interference in any way. And fundamentally, it depends on the respect of the citizenry of the judicial processes that occur. People can disagree with results, people can challenge results, people can appeal results, but we respect the judicial process, the judges, and the juries, and the appellate justices. That's a fundamental element of our democracy.
I'm not talking about types, like, 5 guns, 500, or 5,000. Do you believe there should be no limitations on quantity of guns?
No limitations on what?
On the quantity, on number, 500 or 5,000 guns that I can own.
On the number of guns that people can purchase?
Yeah, for my collection.
I don't think there's any statutory.
Yeah, so there is no limitation. So you agree with that, right?
I
So
don't think there's
if I
any.
have as many guns as I want, in my personal collection, do you think, you have this new rule that you celebrated with your ATF director, which I think is very dangerous? Do you think there should be limitations on percentage of my collections that I should be able to sell, or time frame I can hold a gun? Like, I could buy 10 guns and try to shoot them in the range, they're not good, and I went and sold them. Should be there any limitations on the time frame or percentage of how much of my collections I can replace?
There's an exception in the statute for sales from personal collections.
So I can do as many. I can sell 500 guns, so it shouldn't be a problem, right? If it happens that it's, I just want to replace.
All I can say is there's an exception in the statute and the regulations with respect to sales from personal collections. I don't know the answer to the question about percentages.
Well, it would be good because American people would like to know the answer, because this creates a lot of dangers, and we'll follow up with the latter because, this is called destroy people's life, and we already had the situation that happened in Arkansas. But then another, on the First Amendment, do you think people had the right to be here on January 6th of 21? If they didn't want to do anything bad, they just be here in Washington, D.C. Do you think it's a constitutional right for people to be here?
Yes, people have a constitutional right to be in Washington, D.C.
That's right. So you have, how many Americans did you charge at Section 1512C2, obstruction of justice, and convicted?
I don't know the answer, but it's listed on the web page.
Yeah, so it's several hundred, a lot of people. Why this section was legislated? Do you know when the Section 1512C2, what is the reason that the section was legislated?
It has to do with obstruction of a
No, it didn't have to do. You should know legal history, right? When it was legislated and why.
You're asking me a question the Supreme Court's about to rule on.
Okay, so the history, this section was legislated for Sarbanes-Oxley with Enron situation to deal with a situation that happened on the financial crimes, right? And actually, the title is tampering with a witness, victim, and informant. Is that correct? You agree with that?
We can have a long discussion on the
Not a discussion, it's just a fact, the historic fact. When it was broad and ambiguous, but that's what was legislated.
The text of the statute does not make the limitation you're saying. All of this has been argued in the Supreme Court.
Okay, it's argued. And if your interpretation is wrong on the Supreme Court, and Supreme Court is going to reverse this decision, do you have a plan? What are you going to do with all of these people that potentially wrongfully was charged? Do you have a plan?
Our plan is that we will follow the law that the Supreme Court tells us. We don't know yet what the Supreme Court will say.
Mr. Attorney General, I want to go back to the Mr. Colangelo questions that I didn't quite get answers with. Is it true that Mr. Matthew Colangelo, who was at one point the third highest ranking official at the DOJ, joined Bragg's DA office in New York before the Trump prosecution? Do I have that right?
I don't know anything other than it's on the public record. He was the principal deputy to the Associate Attorney General, and he joined the case in New York. I don't know how it related timeline to the prosecution.
Has anyone from the department, your department, been in touch with Mr. Colangelo or ever discussed any of the case about President Trump since he left?
Look, we have 115,000 people in the department. I can speak for myself. I have not had any communications with Mr. Colangelo.
So you don't know if anyone in the department has?
As I said, there's 115,000, and I don't know what they've talked about.
So if I asked for further information and sent you a letter, could I get some of these questions answered? I've asked for correspondence. I sent a letter back in April and haven't received a response. You said in your testimony that you've gone to extraordinary lengths get Congress information they request?
Yeah, look, I'm in favor of transparency because I believe it will show that these allegations about some kind of control or collusion between the department and the independent Manhattan office are not true.
So then would you...
We'll take back your letter and we'll try to get a response to you.
To kind of follow up with what Mr. Gates said earlier this morning, will you commit to releasing any communications between your department and the local DA offices in New York or Atlanta with respect to these Trump trials?
I'm going to commit to look, I would like transparency on this matter. In the normal course, if you submit your letter, our Office of Legislative Affairs will get a response to you.
Because I think one of the problems here is we hear you criticize some of us for being critical and accusing you all of a two-tier justice system. We use the term weaponization of government, but then when we ask you all for information, you tell us we can't have it, or you've decided that we shouldn't have it. So it's difficult when you criticize us, but we don't get the information we're asking for.
I'm not criticizing you, and in fact, we produced 92,000 pages of documents in response to hundreds of requests.
You've called some of the things we've said conspiracy theories. I won't read back your testimony to you, but I've printed it since your office posted it online this morning. And I would just ask you to work with us because it's difficult for us to tamper down some of these claims that you say we're making when we don't get the information we request from you all.
In a notice filed with 2 federal judges in Washington on Tuesday, the Justice Department said it had reached settlements of legal claims that fired FBI agent Peter Strzok and former FBI attorney Lisa Page brought in 2019, alleging that the disclosure violated their privacy. So again, I just want to be clear that the department is getting ready to pay Peter Strzok and Lisa Page some money. Is that accurate?
I wasn't aware that we'd announced it. All I can say is we reached settlements based on our litigators' assessment of whether we can win the case and how much it will cost if we lose the case. That's the way we decide on reaching settlements.
Just to be clear, the guy who texted Peter Strzok, who was involved in the spying on President Trump's campaign, who was then involved, worked on the Mueller investigative team, and sent this text message to Lisa Page, just went to a Southern Virginia Walmart. I could smell, in all capitals, I could smell the Trump support. That guy's going to get tax dollars from the American people?
That case is he brought a case under the Privacy Act. The question is, did the Justice Department violate the Privacy Act?
Lisa Page said this in a text message to Peter Strzok: Trump's not ever going to become president, right? With a question mark. Peter Strzok's response: no, he's not. We'll stop it. And these 2 individuals are going to get a windfall of money from the American taxpayers because you decided that's the right thing to do?
The Privacy Act doesn't distinguish between people we like and people we don't like, information we like and information we don't like. If somebody in the government discloses personal information protected by the Privacy Act, that's the way the law is.
Jeepers, you can go after a president and you get rewarded for doing so, according to the Justice Department.
Following the release of an undercover video indicating that the DOJ was working with the IRS to use artificial intelligence to surveil bank accounts of Americans in a clearly unconstitutional manner. The undercover video featured an IRS official privately admitting that the IRS had been using AI to spy on Americans' bank accounts en masse in real time. The IRS official further stated that the Department of Justice and Inspector General controlled this AI-powered warrantless surveillance system, not the IRS. Attorney General, would you agree with me that if the federal government were operating this form of financial surveillance program, there would be serious Fourth Amendment as well as other statutory and civil rights implications, considering that there is no individual probable cause and no search warrants are being obtained?
I would be stunned if the Justice Department has the kind of AI capabilities that you're talking about.
Would you agree with me that would you agree with me?
Learn about this.
Would you agree with me that if they were engaging in that kind of surveillance, it would have serious Fourth Amendment implications?
I can't understand the kind of surveillance that you're talking about. Fourth Amendment prevents unreasonable searches and seizures without a warrant. If that's what we're doing, then of course that would violate the Fourth Amendment.
Okay, so I would request that you go back and read the letter that Jim Jordan and I sent to you. That might clear up your confusion just a bit.
One of the things that he pointed out, in fairness, was that the U.S. Marshals take a large role when it comes to the security of judges. But in your role, you have the unique opportunity to actually oversee both branches there. So I'd like to know more about what the department is doing related to threats against judges.
Okay, fair enough. So this is one I can talk about. With respect to the justices themselves, for the first time in history, an attorney general, namely myself, ordered that every justice get 24/7 protection for himself or herself and their families at their residence and on their travel. So I've assigned over 70 U.S. Marshals who are doing this daily, but because of rotations, it's involved almost 1,700 marshals across the country to provide immediate protection. Now, the FBI, both the marshals and the FBI investigate threats against the justice. This is in our highest priority band protection against the judges, protection against threats against justices and judges. And I'll be happy to provide you with the press releases of our charges.
Mr. Gates talked about Mr. Colangelo earlier. Mr. Colangelo was acting Associate Attorney General for the Justice Department under President Biden prior to your arrival. Is that my understanding?
That's right.
And is that considered to be the third highest ranking official within the DOJ?
Yes.
Okay. What did he do prior to his service with the Department of Justice?
I didn't know Mr. Colangelo before. My understanding was he had once been in the Civil Rights Division. I don't know his resume.
Would it surprise you to know that he was the Deputy Director for the Obama-Biden administration's National Economic Council?
Wouldn't surprise me or not surprise me. I don't.
Were you aware also that he worked for the New York Attorney General, Letitia James, for a period of time?
I've read that in the paper.
Okay. Would it surprise you to know that he was paid thousands of dollars by the DNC for political consulting in 2018?
So that I have no idea about.
So I think the issue that we're having is that it looks like that this particular gentleman, his whole mission seems to be prosecuting a president. He started off with Letitia James. He has a stint with the Department of Justice. And then Mr. Gates kind of talked about this earlier. Normally, if you're going for something, you start out at a DA level and then you might move to the Department of Justice. Like it's an elevation. He has gone backwards. Why is that, you think?
Let me just set forth the whole thing here if I can, okay? I know Mr. Colangelo because of his service in the department. He's a highly ethical person and an excellent lawyer. The Associate's Office supervises the Civil Division, the Civil Rights Division, the Antitrust Division. That office does not supervise any of the criminal components that supervise the criminal investigations of Mr. Trump.
Don't you think, though, Mr. Attorney General, that his career choices, the path that he has chosen, at the very least, poses the perception of an ethical issue for the Department of Justice?
No, I don't see how it poses any issue for the Department of Justice. He's not an employee of the Justice Department. The Justice Department did not send him to New York. Those decisions in New York are made by the DA of New York.
Well, fair to say, but we have Manhattan DA headline, Manhattan DA hires ex-senior DOJ official as office investigates Trump. Another one from the New York Times, Manhattan DA hires ex-justice official to help lead Trump inquiry.
But you and I both know in a criminal case that if you have the recording, I'm going to eventually get it as the defense attorney. So I'm trying to figure out what your guys' policy is on recording of interviews and recording of witnesses. Because if it was what it really says it was, we wouldn't have had to introduce the FAIR Act.
Well, like you say, there are very few things that are before my time, but that one does seem to have been before my time. I don't know the answer to the policy about recording. Personally, I think recording interviews is a very good thing to do for all the reasons that you say. But of course, as a former defense attorney, you know that the defendant has to agree to the recording of the interview.
We've been a part of it in this committee too. And I get the rules of evidence in a criminal case are different than an adversarial between the Department of Justice and Congress. But our frustration and my personal frustration is whenever you're in an adversarial system, The other team doesn't get to determine what is the best evidence.
Without objection, the hearing is adjourned.